Are you an attorney to a family member and had a letter from the Office of the Public Guardian, known as the OPG, telling you that they have opened an investigation? This investigation letter runs into 15 pages and you've been given just a couple of weeks to reply to justify every penny spent. We think this is unreasonable and unfair. Many people do fill in the form the OPG sends and unwittingly fall into traps that result in even more pain. Sometimes it can even lead to the authority they have to manage a family member's affairs being taken away, and in legal language, the lasting power of attorney being revoked. A typical reason why the OPG will start an investigation are allegations of unlawful gifting from the money of the person who made the lasting power of attorney. Being an attorney is a serious responsibility, and the law can be confusing. People often don't realise they are not allowed to make these gifts to themselves or others. As far back as 2013, a senior judge says that ignorance of the law is not an excuse. We think this is a little harsh, especially when our textbook is some 2,000 pages of very, very small print. But that is the law. The OPG may ask about money that doesn't seem to have been spent for the person who made the LPA. We do our best for our clients, but even we found it hard to justify the purchase of a dog by the attorney, going on a spa break, or paying for a parking fine for driving a bus lane because they were thinking about mum at the time. But seriously, many attorneys are asked to explain how making of gifts to themselves is in the best interest of the person who made the LPA. If you are faced with an OPG investigation, what can you do? Does the OPG even have the right to ask these questions? A very important point is to check if the person who made the LPA still has mental capacity to make decisions for themselves. If they do, then they can decide how to use their own money, and this could be the end of the matter. At Steen Law, we had a client who'd been faced with allegations that her 85-year-old grandfather could not possibly have bought 6 Apple Watches, and the OPG accused the attorney of unlawfully using her grandfather's money. We instructed a mental capacity expert who told us that the grandfather was able to understand what he was doing when he bought the watches as Christmas presents. And once the OPG understood this, they were forced to close their investigation. The form needs to be filled in very carefully, and that's where we at Steen Law come in. It's our job to make sure you understand the steps that you need to take as an attorney. Sometimes an Office of Public Guardian investigation will have started because a local authority has done a means test and seen a large gift that has been made and alleged there has been a deliberate deprivation. Local authorities or social services are quick to say an attorney has diverted assets on purpose so that the money cannot be used to fund care. But what local authorities often do not do is correctly work through the legal tests they need to prove that there has been a deliberate deprivation. We have successfully acted for attorneys who are alleged to have moved assets to avoid having to pay for care fees. And when we've looked closely, all the elements that a local authority has to prove are absent, and the investigation has to be closed. A word of warning: before you reply, if you find yourself on the wrong end of an OPG investigation, a call to Steen Law will not cost you anything for a chat. Almost every client has said that after speaking to us, it's the first time they've been able to have a good night's sleep since receiving the letter.